Hello guys, this is Farhan Ahmed and today we are going to talk about corporate criminal liability. Here we are going to talk about the laws, the breach and the punishment that the corporate world may face if they do something illegal. So the things that we will be learning from this video are the concept of corporate criminal liability. We will also be learning some of the laws and acts that are regarding to the corporate criminal liability in the Companies Act 2013, and I will also be presenting some of the examples or cases that are regarding to the corporate criminal liability in India. So at first, what is corporate criminal liability? Corporate criminal liability in India under the criminal law provides for the extent to which a company is as a legal person or a separate legal entity is liable for the acts done by the employees of the company. The corporate criminal liability in India is governed by the norms of the vicarious liability as distinct from the scenario in which the statute offense specifically makes the company liable for the particular offense. From this we can understand that in corporate criminal liability, the business only comes under fire when the illegal activity is done by the employees, but they also have to face the consequences due to the employees working for them. So why is a company liable? As the main point is, a company is a separate legal entity according to the law, and when it is registered or incorporated once in Companies Act 2013, any corporation becomes an artificial legal entity which can be sued and can sue other person or entities. Here the company can also get properties in its name and also get bank accounts like a normal person would have. So generally the question is asked, which is according to respect to the corporate liability, is that a corporate being an artificial person is not capable of committing a crime, or whether a corporation is criminally liable for the said criminal act. Traditionally, it was held that corporation cannot do a crime as the main test of criminal activity lies in the intent. However, the concept of corporate criminal liability under the Companies Act has been recognized. According to one of the foremost British scholars in the criminal law, Glanville Williams, a company can only act through human beings, and a human being who commits an offense on account of or for the benefit of a company will be responsible for that offense himself. The importance of incorporation is that it makes the company liable in certain circumstances as well as the human beings. So from this we can understand that a company can't commit the crime itself, but the people who are working for it may commit the crime themselves, and the company will be liable for that. So now we are going to talk about corporate criminal liability in India. Companies Act 2013 now recognizes criminal corporate criminal activity as criminal activities in its law. Corporate criminal activity in India has gained much more momentum in the preceding year, especially in the spheres of standing such as consumer protection, environmental law, occupational health and safety norms. The concept of corporate liability is closely concerned with the corporate governance policy of an organization, as if a corporate follows good governance structure, then the possibility of criminal negates and the question of criminal liability does not arise. Over the times, even the Indian judiciary has also pointed out that a corporation can also be a part of criminal conspiracy and can be held liable criminally. This is for the first time was said in by the Supreme Court in the case of Iridium Telecom Limited versus Motorola Incorporated. Thus, it can be said that corporate criminal liability has been recognized as one of the corporate liability in India under the Companies Act as well as under criminal laws. So before we delve into the acts regarding CCL or corporate criminal liability in Companies Act 2013, I want to point out something. Companies Act 2013, which has replaced the Companies Act 1956, has also increased the corporate liability of the directors. The Act has also increased the monetary penalties and imprisonment. Not only corporate criminal liability under Companies Act 2013 is recognized, but the Act also recognizes civilian liabilities. The Companies Act 2013 not only makes the director criminally liable, but also include officers in default under the concept of corporate criminal liability in India. The term officer in a default is a broad term and can include whole-time directors, key manager personnel, and such other directors in the absence of manager personnel who has been specified by the board of directors, and every other director who is aware of the default which is being done by the virtue of receiving board proceeding or by participating in same without raising any objection, or where non-compliance has taken place with his or her consent. So here are some acts regarding to corporate criminal liability in Companies Act 2013, Section 53, which is prohibition on an issue of shares on discount. The company will be fined for the amount not less than 1 lakh, but which may extend up to 5 lakhs. Further, the company in default may be imprisoned for up to 6 months or fine of minimum 1 lakh, which may extend to 5 lakhs or both. Then the other law is Section 118, Article 12, in which minutes of proceeding of general meeting, meeting of board of directors, and other meeting and resolution passed by the postal ballot. If a person is found tampering with the minutes of meeting, then such an officer in default may be in prison for the term which may extend to 2 years, or with fine of more not less than 25,000, or may extend to 1 lakh. The next law is Section 128, subsection 6, in which the books of account, etc., to be kept by the company, where officer in default is liable, where if he has done any fraud or any fraudulent work, he will be charged not less than 50,000, which may extend up to 5 lakhs or both. And then we have another law, which is Section 129(7), which is the tampering with financial statement. If there is any tampering with the financial statement of the company regarding the balance sheet and profit and loss account to show false information, then the officer in default will be charged of maximum imprisonment of 1 year, and fine will be given of not less than 50,000, or which may extend up to 5 lakhs. And then we have Section 134, which is also the extension of the 129, where if there is any tampering with the financial statement or board's report, then the company will be fined of not less than rupees 50,000, but will be extend up to rupees 25 lakhs. And if it is found that the official default is the main accused, then he will get the maximum prison of 3 years and the fine of 5 lakhs. Then we have another section, which is 188 subsection 5, which is the related party transaction. In case of unlisted company, it will be punishable with fine which shall not be less than 25,000 rupees, or which may extend up to 5 lakh rupees. Then we have another section, which is Section 57, where there is punishment for impersonation of a shareholder. If there is any person who is impersonating the shareholder or the board of member of the company in the legal proceeding, then such person in default will have a minimum 1 year to maximum 3 years of imprisonment, and will be fined not less than 1 lakh, which may extend to up to rupees 5 lakhs in fines. So another law or act in Companies Act is Section 184 subsection 4, which is the disclosure of interest by the director. Such person in default may will face minimum 1 year of imprisonment or fine of up to rupees 50,000 or 1 lakh. And then we have another section, which is Section 187 subsection 4, which is the investment of the company to be held in its own name. If any director or the key manager person has held the investment of the company in under their own name in any bank account, they will be fined not less than rupees 25,000, which may extend up to rupees 25 lakhs. An officer in default will be charged with maximum imprisonment of 6 months, or with the fine of rupees 25,000. Then we have Section 447, which is punishment for fraud. If any person is found guilty of fraud in any the transaction of the company, then there will be a maximum imprisonment of 6 months, which may extend up to 10 years if found guilty. Such person is also liable to the fine, which may extend up to 3 times the amount involved in the fraud done. So corporate criminal liability is mainly based on two models, or two major models, which are derivative model and organization model. Derivative model, as the name suggests, under this model of corporate criminal liability in India, the liability of organization is a derived liability. The liability of a corporation is derived from the action of an individual who has been employed or connected with the organization or commits a wrongful act. The liability is put on the organization because of the connection of the individual with it. The derivative model of the corporate criminal liability is further subdivided into two categories, which is vicarious liability and identification doctrine. So let's discuss our vicarious liability. The doctrine of vicarious liability is based on the two legal Latin maxims. The first maxim means that he who acts through another shall be deemed to have acted on his own, and second, respondit superior, which means let the master answer. Vicarious liability is the concept which is generally applicable in case of civil liability, but the courts have said that because a corporation is an artificial person according to the Companies Act 2013 and a separate legal entity, thus it is necessary to bring the applicability of vicarious liability in the case of corporate criminal liability. And now the next one is identification of doctrine. So identification doctrine is an English law doctrine which tries to identify certain key persons of a corporation who acts in his behalf and whose conduct and state of mind can be attributed to that of a corporation. As the liability of this key person who act on the behalf of a company, it was held in that the person who are identified with the corporation must be acting with the scope of the employment or authority. The conduct must occur within an assigned area of operation, even though particulars may be unauthorized. The scope of identification doctrine is narrower than that of vicarious liability. Now let's talk about the organizational model of corporate criminal liability. This model of corporate criminal liability in India focuses on the model of organization while defining the corporate liability of an organization. In criminal cases, a crime is said to be committed when there is a presence of mens rea, intent to commit a crime, and actus reus, a criminal act or omission. But the problem which arises while holding a corporate criminally liable is that how an artificial person can have committed the mental intent to commit a crime. The culture of a corporate may help for a commission of an offense requiring mental state by firstly providing the environment or necessary arrangement or encouragement that it was believed by the offender working in the corporation that it was perfectly all right to commit that offense, or corporation that has psychologically supported the commission of the offense. Secondly, it is quite possible that the corporation created an environment which led to commission of crime both ways. It was the corporation and its working culture that led offense to be committed. So now we are going to talk about some of the cases regarding the corporate criminal liability in India. So the first case is before corporate criminal liability came into being in India. So it was Z Telefilms versus Sahara India Co, where the court dismissed the complaint on Section 500 of Indian Penal Code, alleged that G has telecasted a program based on falsehood and thereby defamed Sahara India, held that mens rea was one of the essential elements of the offense of criminal defamation and that company could not have the requisite mens rea as the company is an artificial being and does not have a mental intent to do the offense. The next case is Standard Chartered Bank versus the Directorate of Enforcement, which took place in 2005. It was the most defining case in the corporate criminal liability in India, whereby the Standard Chartered Bank was being prosecuted for violation of certain provision of Foreign Exchange Regulation Act. Supreme Court held that the corporation could be prosecuted and punished with the fines regardless of the mandatory punishment required for the respective statute. In this decision, by implication, can be said that the post-Standard Chartered decision, corporations are capable of possessing the requisite mens rea. As in prosecution of other economic crimes, intention could very well be imputed to the corporation and may be gathered from the acts and the omission of the corporation. So, Iridium India Telecom Limited versus Motorola Inc. was one of the case which came after the post-Standard Chartered Bank case. In this case, the apex court held that the corporation is virtually in the same position as any individual and may be convicted under common law as well as statutory offences, including those requiring mens rea in this case. So, in conclusion, the wave of corruption scandals is affecting India very badly. In order to fix this, it is relevant to examine criminal liability not just of individual directors or agents or of a corporation but also of the company itself. Although considerable debate surrounds society's increasing reliance on criminal liability to regulate corporate conduct, few have questioned in depth the fundamental basis of imposing criminal liability on corporations. Tells us that law does not contemplate something which cannot be done. But the statutes in India are not in pace with these developments, and the above analysis shows that they do not make corporation criminally liable, and even if they do so, the statutes and the judicial interpretation impose no other punishment except for fines. So it is inevitable to take some serious measures in relations to the criminal liability of corporations so that it could be stopped from multiple dimensions of the court decisions. So guys, if you learned anything from this video, please leave a like and thank you for watching.